What you'll be doing today is hearing from 4 panelists. This will be the run of the show, and then we'll be opening up at the end for a Q&A. The Q&A function, which is available at the bottom of your screen, that will be open throughout the whole session. So please feel free to use this if you have any questions for panelists throughout, as we'll also be able to respond to you in real time. And if you would also like any assistance with tech, please also use the chat function for that. We'll also be utilizing the translation function today with presentations taking place in English, Spanish, and Khmer. So here you will see how to use that. Everyone should now have access to the interpretation button at the bottom of their screen. Please click on the interpretation button. We've got an icon there on the slide that should show you what that looks like. So if you click on that, you should then be able to select the language that you'd like to listen to the session in. And it may help if you would like to mute the original audio while you're listening to a different language to the language you're listening in. That can help, but that's an option. So I just want to draw your attention to that. And again, if there are any technical issues, please use the Q&A function. Thanks for all of you for joining today. Kim, if you want to stop sharing the slide, thank you so much. And a huge thank you to the wonderful panelists we have today as well. It's first day of the OECD forum, and we're really glad that we're able to share with you today as part of this side session program. We're hoping that what we're presenting today will be a very timely session to consider how brands have responded to the discovery of violations in their global supply chains and how they've approached remediating these violations of rights when they're presented as violations specifically of local laws in production countries. So before I pass on to our fantastic panelists, I'll just explain a little bit about WRC's approach, because there may be people joining in the audience who are unfamiliar with that. And I want to consider what remedy looks like through our lens in terms of how we approach it. But first, I'd like to put forward 2 elements of broader context to consider as you're listening to our panelists. And these will be relevant to all of their interventions regarding their experience of pursuing remedy. The first is, of course, the CSDDD law in Europe, which we're, of course, hoping won't be watered down, but what this will practically mean for bringing about liability for lead brands when due diligence fails to prevent abuses. Bringing in these laws has, of course, attracted a great deal of focus for many of us around what compliance will look like for brands in the footwear and apparel sector, and the extent to which this could change the way in which brands are held responsible for rights abuses in their supply chain. The other key element of context that I urge you to consider is, alongside the emergence of these new accountability laws, is the extent to which the civic space is already under threat in garment-producing countries, with rising authoritarianism already undermining the ability of workers to assert their rights under the legal frameworks in their own countries. And I think this broader national context is incredibly vital because worker rights are inextricably intertwined with a functioning democracy and an open civic space, as many of you know. When democracy declines, so too does respect for worker rights in global supply chains. Democracy provides an enabling environment for worker rights to be expected, with all those functioning elements of an open civil society playing really important roles: freedom of speech, freedom to organize collectively, to defend and further rights, a free press, and the ability, of course, to hold government accountable. But what's relevant here is how brands have responded to this trend of a closing civic space. One significant area of weakness that has been exposed in this context is the widespread ineffectiveness of brands' approach to monitoring rights through a traditional social audit approach that relies on a one-size-fits-all model. This has actually been demonstrated and even understood to an extent by brand themselves as being insufficient, because what happens outside factories clearly has an impact on workers' ability to protect their rights within them. Yet what we often see, including in the cases that you'll hear about today, is that despite garment-producing countries often having quite robust labour laws, brands and retailers still fail to ensure that these basic standards are complied with, despite their outward commitment to these local labour laws. This is vital to consider, as this failure by brands and retailers worsens the erosion of the rule of law in countries already facing these challenges. This is at odds with the narrative often emanating from global north stakeholders that presents garment-producing countries in the global south as often lawless or inept, with manufacturers taking on a disproportionately large share of responsibility for labour violations, when in fact it's the commercial practices of brands themselves that are often the root cause of many of these violations that we come across. And their significant compliance demands on manufacturers in the form of social audits often fail to identify violations. So very briefly, for those of you who are perhaps unfamiliar with the work of the WRC, we monitor, investigate, and remediate cases of labour violations in global supply chains, and these are reported to us through frontline organisations like labour organisations and unions. We utilise a framework of presenting our findings to brands that is in line with relevant national legal frameworks, which all brands have an obligation to respect. We take a particularly robust approach to documenting violations that takes into account this broader political context. Our local staff in garment-producing countries monitor, therefore, not only the working conditions within factories, but the political and economic context in country which have a direct impact on worker rights. This ever-shrinking civic space in garment-producing countries is creating new challenges with access to remedy, as these constraints limit our ability to rely on the independence of institutions within these countries that previously provided just legal outcomes for workers. This is then exacerbated by this audit-heavy system employed by companies to monitor supply chains, which don't take these changes into account. For all of the cases that you will hear about today, as with all of our investigation and remediation work, the WRC has documented these violations under a legal framework. And when we're speaking about remedy, what we are talking about is remedy to the fullest extent under the law. So for example, if workers in Thailand are owed 8.3 million US dollars, we will consider remedy complete at the stage in which that has been done. And that's because we're using specifically a legal framework within the country in which those garments were produced. And I should note that we remediate cases at a pace of 1 every fortnight, and more than 85% of our cases are actually remediated through direct communication with brands rather than needing to escalate this in any way. So taking just the issue of unpaid severance alone, this is, of course, a right that's enshrined in the labour laws of most garment-producing countries. And in the past year alone, the WRC has secured 23 million US dollars in back pay for 10,000 workers in 7 countries. And this has contributed to the $150 million in severance that the WRC has recovered for workers who otherwise would not have received what they were legally owed. And of course, while there's still a substantial number of cases that don't get resolved, what the key changes that we'd like to uplift here is that there are now lead brands that will step up themselves to fulfill their responsibilities by directly financing remedy of these violations. And that, of course, has huge implications for garment workers across the supply chain. And I think particularly in this industry, we can't overstate the impact that this approach to remedy has had, where brands tend to look to each other for the bar on what kind of labour violations are acceptable and what are not. So just to give you 3 very quick examples, in the past year, this has involved a case in Jordan where migrant workers in a factory producing for PVH, which is the overarching company for Calvin Klein, for example, where they had been deprived of months of pay, and the WRC used leverage directly with those brands to ensure that 3 million US dollars was paid to workers that they otherwise wouldn't have received. And really crucially, given that these were migrant workers, they were provided a safe passage home to countries in South Asia. In another case, workers in El Salvador received $1.8 million in severance, paid for again directly by the brand Outer Stuff. And in this case, crucially, many of the workers were receiving actually the equivalent of more than 1.5 years of wages. So, of course, having a profound impact on the quality of life of the workers and their families. And in another case in Haiti, the brand, in this case, Gildan, returned nearly $1 million in arrears to workers. I'm sharing that just to give an indication of the fact that this trend we're seeing towards brands stepping up and paying is a very interesting one, and one that we weren't finding when we started doing this work on severance 20 years ago. This is also why protecting freedom of association is the cornerstone of our work and what we'll hear about quite a bit today, since this enabling right allows us to identify other labour rights violations. It allows us to work towards remedy and expand precedents for enforcing labour laws. We therefore strategically investigate and remediate quite a large number of freedom of association cases each year. In fact, they make up the lion's share of the cases that we work on. So in the past year alone, 2,000 workers who were wrongfully terminated for organising within within apparel factories have been reinstated with back pay. And of course, that takes a considerable amount of effort for the local unions that are working on these cases, as well as for the WRC. But we all collectively see this as vital for ensuring that the rule of law and freedom of association is not flouted in all of the countries. Now to our session, just let me have a sip of water. Our panelists today will be offering first-hand reflections of the remediation process of rights abuses in the global apparel supply chain, and provide analysis of how this evolving industry response to various forms of remedy can inform approaches to undertaking effective rights due diligence. This is particularly relevant, as I said at the beginning, in the context of existing laws already frequently being flouted by brands. It then becomes quite relevant for us to consider how we can ensure that future laws provide greater brand accountability for the root causes of labour violations, rather than simply a greater compliance burden for manufacturers utilising the same audit approach that has been unsuccessful largely in identifying legal labour violations. So without further ado, I would like to introduce our first panelist. I'm so thrilled that she's able to join us today. Dr. Pratibha Ramanath is a prominent worker rights activist and a former garment worker herself. She serves as the president of the Garment and Textile Workers Union, or GATWU, a grassroots union that organizes and fights for the rights of garment workers in the state of Karnataka. She will be sharing just one example of the incredible work that they have done as a union. And, you know, they really stand out to us as a union that has really done an incredible job of utilizing the Indian labor law and using that with which to then push for remediation with brands. So I'll turn over to you, Pratibha. Thanks so much.
Hi everybody. Thanks for this calling me for this session. I just wanted to share with you all that how international brands will hide behind their suppliers when the violations of laws will happen. So I just wanted to bring that in Karnataka, 400,000 workers are there, and in this 85% are women, and these women are all coming from very low, with very low education and backward classes. And in Karnataka, these workers are, I'm saying today about the wages, how they are facing the problems with wages, and how the employers will theft their wages in various ways, and how the brands will hide behind the supplier, their suppliers. So in this, in Karnataka, workers will pay minimum wage, which government of Karnataka will fix. Only that much only they will pay, and it is very, very low. And the minimum wage will have two components, that is basic and VDA. This VDA is variable dearness allowance. That is for annual cost of living increase. So every year it will increase to balance the way price hike. I think from 40 to 50 years of history of garment industry, VDA payment is very much problematic always. The manufacturer will not give VDA properly. When GATWU starts its work in 2006, it is continuously campaigning to pay the VDA properly to the workers. Now they're getting the VDA. I'm telling this case in which was happened in 2020 when the corona pandemic has happened. So in corona pandemic, India has locked down from March 21st to May 14th. 2 months, garment workers have not received their wages. And the government has not done anything, and their suppliers are not done anything. They literally didn't get any money, any wages, and they lost their jobs, and factories have closed down because of brands have withdrawn their order and stopped their order. So these are all happened. So workers were all in very, very desperate situation at that time. So in 2020, that VDA is the calendar year. The VDA will start from every April 1st to March 31st. That is financial year. So when in 2020, VDA has increased about 16 rupees per day. That is 417 rupees per month. That will come to 4.7 euros something. So workers has to get that wages, that VDA in with their wages of May month in 2020. But these suppliers have gone to Karnataka government and said that they are in very much desperate situation. They were not able to pay the VDA, and please suspend the VDA for 4 months or something. But Karnataka government has done this as they have come with a notification, government notification, that to help the employers, we will postpone the VDA payment for 1 month, 1 year. That is April 2020 to March 2021. So it's a very, very illegal thing. Immediately, including we, all the central unions went to file the writ petition in the High Court. Because VDA is the part of minimum wage, and not paying the VDA is the violation of the Minimum Wage Act, that is Act 1948. So court also heard us, and in 1 month, this notification has came on July 20th, 2020 by government. Immediately we went to the High Court, and High Court said that the strong prima facie case is made out. The result of the impugned order is that the employees will not be entitled to VDA, which is an integral part of the minimum wages fixed under the provisions of the said Act for the period specified in the impugned order, and the employees will get VDA for the said period only after the expiry of the said period. This is something which is clearly impermissible under the said Act, and especially keeping in mind the object of the said Act. The impugned order, as observed earlier, is expressly illegal and deserves to be stayed. So, High Court stayed that government order. It has happened in September 2020. Immediately, even after court has stayed that, management suppliers have not given the VDA to their workers. Why it is very important, I'm telling, because all these women workers are depending on their money, their wages. They are getting hardly at that time 8,891 rupees. At that time, the minimum wages was 8,891 rupees. If 400 rupees were added for their ages, it will be very, very useful for them. Because that too, in the pandemic situation, they were all in very desperate situation. They had not taken their wages. They are struggling for their wages. They lost their employment. So people will, the women will tell, they are crying that why this, because they are not getting any increment for their services. They will only get the increment only. It's not increment. The increase the wages is only by this VDA. So VDA suspension is very much problematic to them, that they said that if we would have get that, we can fed their our children with some vegetables, some this one. And even in the pandemic situation, workers have said that no, we can't pay our rent, and we came out from our house. We will be in one small room like that. So like that, it is happened for every woman. Because in Karnataka, 60% of the women are single earner for their families. Their families depending on their own earnings. So it is very unhuman thing that even for 400 rupees management has not paid, and brands have not considered this their supplier, their producers. See, because for brands, these women are producing for them. So they have the responsibility, huge responsibility on these workers. So GATU, after this, when even after the court stay, management have not paid, and then one thing I have to say that in Karnataka, we are producing for all major brands, that is M&S, Adidas, PVH, VF, A&F, Columbia, Primark, C&A, Gap, Levi's, Nike, Tesco, H&M, and Inditex, Puma, everybody we are producing. So then we wrote to letter to all the managements on May 2021 that this has happened. So you have to pay the workers. At that time, it was from April 20 to May 21. That is 13 months already has passed. So no response has come. Afterwards, we went to government departments. We wrote letter to Deputy Labour Secretary, Joint Labour Commissioner, Deputy Labour Commissioner, Chief Secretary of India, Karnataka. So everybody we wrote letter, and we gave the memorandums. We went to delegations. So nothing has happened. Next, we wrote a letter to all brands that this is happening. Your suppliers are not comply with the local law, which court has already said that. So we wrote all the letters. Nothing has happened. Then we started in October 2021. We started media campaign. We wrote. We called press meet, and we went to the media. All the leading daily papers has covered this in the local language, and English papers have covered this, and they have also said that in their editorials that this is a very clear wage theft thing. So nothing has happened. Then we approached the WRC and other international organizations, requesting them to help in this matter by pressurizing the brands and all. Now it has started. Then after our all efforts have gone and workers have suffered so much, these brands are coming with their own statement. Yeah, we are very much serious about this. We are stick to our code of conduct, our local law. So something they are saying. So every brand have said that, oh, we are looking into it very seriously like that. So when we wrote to brands in May 2021, they have not even considered our letter. They are not even considered. And we saw in many cases that brands will say that the law is interpreted differently by union and management. So we are not in this. So they have to settle their this one. So brands are always hiding behind the suppliers, always support to their suppliers when these serious violations will happen. So brand WRC and other the international organizations have took up this and campaigned, and Guardian has reported this one. So at last, Shahi Exports, one of the major exporter supplier in Karnataka state, have came up with, yes, we will give. And it's an industry level decision. And Shahi came up with this statement that we are giving the VDA, pending VDA, to workers. It is at that time, it was 417 rupees into 22 months. Workers have to wait 22 months for their own money. So that has come to $60 million for 4 lakh workers. So management has gave that to who are all working in one shot. They gave 9,000 rupees something has come, 417 into 22 months. And workers who have left job, they were called and they have paid. So this was one. It's a very because in the garment sector, workers have once gone, management will not pay anything to them. But in this case, they have called the left out workers and paid this amount. So this is one solid case. Like this, GATU always doing, whenever the local law violation, it will go to the court, it will use the legal thing, because our laws are very, very strong. But the implementation is very, very poor. So these brands will say that we will see that our suppliers will comply with the local laws and all. Whenever we go with the violation with two brands, they will say something. No, it is wrong interpreted. It is in court. Let that finish. So whatever the suppliers will say them, they will stick to it. They will not heard about what workers are saying. So this has happened in many cases, in individual cases, in industry level cases, in factory level cases. Always, I don't have time to explain all the cases, but this is one case. Workers have got that much huge money waste. The waste theft has happened. It's a huge money has they got. Otherwise, if GATU has not went to court and bring the stay to this, or managements have forgotten this amount, 417. Up to here, if we calculate 407 in 2020 to 2025, this one, it will come about 10,000 crores, 1,000 crores amount. So like this only, it is negligible amount for anybody. That 417, what is there like that? But if we see as a whole, as industry, it will make very big amount, and it's also a very big amount for an individual worker, because they are in that much such the desperate situation. I want to tell another one thing is, See, in 2020, they have only 8,891 rupees minimum wage. Today is 2025. Today, their wages is 12,223. So, the difference is only 3,332 rupees. 3,332 rupees in 5 years. Per year, it will come only 600 rupees, 666 rupees. That is only 7 euros. 7 euros increment. It's not increment also. 7 euros, they will have the increment in their wages. This is how workers are in India. In India also, in all garment producing countries, workers are paying very, very low and very, very poor wages. And GATU is fighting for this from 15 years, but still whatever workers are getting, it is from GATU's effort, but still it is not sufficient. Still we are fighting with our government to increase the minimum wages, but our supplier lobby is very much, and brands are saying that we will see that workers should get the wages to meet their what do you call, to meet their needs, like that. But nobody, see, if we said that, if we go to the branch that your supplier is lobbying with the government, they will not do anything. We have the record on record that management has wrote to government that we can't give more minimum wages like that. And in Karnataka, other scheduled employment workers are getting 18,000 rupees per month. This garment sector is only getting 12,200 rupees, because this is gender discrimination also. We are fighting as this also. Gender discrimination also, this is they are doing. So our supplier, our government, mainly our brands are not looking about the garment workers who are suffering so much. And we thank all international campaigns on that day, especially WRC also. It took very seriously and did this campaign, and workers got what they owe from their managements. So this is what happening. Thank you.
Thank you so much, Pratibha. That's such an incredible overview of that situation that happened. And just to highlight to everyone who's not familiar with the use of lakhs and crores in terms of the 60 million that was owed to workers, it was 400,000 garment workers in Karnataka that were impacted. And again, it was vital, the role that the GATU union played in terms of filing that very important legal case that led to the outcome that allowed for this to be pursued at an international level. But I do want to uplift also the point that the local union did reach out to brands themselves. And ultimately what this did take is other Global North organizations echoing that. And I think that's something to consider as well, because I'm sure this is not the only grassroots union around the world that experiences that kind of response from brands. We'll come back to Pratibha a little bit later, but for now, I'd like to hand over to our next speaker, Yang Sophorn. Sophorn is the president of the Cambodian Alliance of Trade Unions, or CATU. This is a trade union federation representing workers in Cambodia's manufacturing sectors. Sophorn is a former garment worker herself also, and she has been an absolutely formidable representative of garment and footwear workers for more than 20 years, and has worked with the WRC on many, many cases. And we're really lucky to be joined by her today to share CATU's experience on one of these cases. For those who missed the beginning of this, I just want to point out that Sophorn will be speaking in Khmer, so therefore please select the interpretation. Oh, thank you, Kim. If you could just click on the icon that is showed on the screen right now, Click interpretation, click the language that you would like to hear. If you find yourself getting distracted by hearing the original language, you can switch to mute original audio. If you have any issues, please use the Q&A function. Thanks so much, Kim. And so I will hand over to Sophorn. And just to note, she's experiencing some technical difficulties in Phnom Penh this evening for them, and so won't have her video on.
ចាជាដំបូងសូមគោរពនិងសូមជម្រាបសួរទៅដល់បងប្អូនទាំងអស់គ្នាអរគុណមែនទែនដែលបានអនុញ្ញាតឲ្យខ្ញុំបានចូលរួមនៅកិច្ចប្រជុំដែលមានសារៈសំខាន់នេះហើយខ្ញុំនឹងចែករំលែកអំពីបញ្ហាប្រឈមរបស់កម្មករយោជិតមួយចំនួននៅក្នុងការចងក្រងខ្ញុំលើករឿងករណីក្រុមហ៊ុនស៊ុនស៊ុយស៊ីងក្រុមហ៊ុនស៊ុនស៊ុយស៊ីងនៅពេលដែលយើងចាប់ផ្ដើមបង្កើតសហជីពពួកគាត់ទទួលរងនៅការប្រឈប់ការគម្រាមកំហែងរហូតដល់មានការគម្រាមកំហែងដោយសារតែពួកគាត់សិតតែជាស្រីគម្រាមកំហែងរហូតដល់មានការចោទចាប់ចង់និយាយថាចោទគាត់ថាគាត់សិតតែស្រីអញ្ចឹងបើសិនណាគាត់ចូលរួមនៅក្នុងការចងក្រងមួយសហជីពតែអ្នកឯងអត់ខ្លាចគេចាប់រំលោភអត់ខ្លាចអីទេព្រោះអ្នកឯងសិតតែជាស្រីអញ្ចឹងណាក្រោយមកទៀតយើងឃើញថាបើយើងក៏លេចទៅមើលច្បាប់នៅក្នុងប្រទេសកម្ពុជាយើងទាំងអនុសញ្ញាអន្តរជាតិដែលកម្ពុជាបានផ្ដល់សេចក្ដីបានហ្នឹងគឺបានផ្ដល់សិទ្ធិអនុញ្ញាតឲ្យពួកគាត់បង្កើតសហជីពដោយសេរីប៉ុន្តែវាមានបើយើងមើលទៅលើការអនុវត្តវាទៅជាមានការសម្លុតការគំរាមកំហែងការប្រើប្រាស់ហិង្សាការចោទប្រកាន់ការចាប់ដាក់គុកអីហោហែបើករណីរោងចក្ររបស់ពួកគាត់ស៊ុនស៊ុយស៊ីងនេះយើងឃើញថាមានការគំរាមកំហែងសម្លុតទិញទឹកចិត្តអីជាដើមអញ្ចឹងណាចឹងត្រឡប់មកវិញយើងឃើញថានៅពេលដែលពួកគាត់ទទួលរងនៅបញ្ហាប្រឈមទាំងអស់ហ្នឹងគឺអត់មានដំណោះស្រាយទេនៅពេលដែលយើងប្រើយន្តការនៅក្នុងស្រុកហ្នឹងយើងបានប្តឹងទៅក្រសួងហើយបន្ទាប់មកក្រសួងក៏ធ្វើការផ្សះផ្សាហើយបន្ទាប់មកក៏មិនបានបញ្ជូនទៅក្រុមប្រឹក្សាអាជ្ញាកណ្ដាលដែរវាធ្វើឲ្យរឿងទាំងអស់ហ្នឹងត្រូវបានគេបំបែកតាមពិតករណីនៅរឿងរបស់គាត់គឺជាវិវាទរួមប៉ុន្តែក្រសួងការងារគេបបែកទៅជាវិវាទបុគ្គលហើយបន្ទាប់មកគេក៏អត់បានបញ្ជូនទៅក្រុមប្រឹក្សាអាជ្ញាកណ្ដាលដែរធ្វើឲ្យយើងគ្មានជំរើសទេយើងនៅក្នុងច្បាប់ហ្នឹងគឺយើងមានជំរើសតែមួយគត់គឺគេឲ្យយើងប្តឹងទៅតុលាការអញ្ចឹងសរុបមកវិញនៃករណីក្រុមហ៊ុនស៊ុនស៊ីស៊ីងជារឿងមួយដែលគេមានចេតនានៅក្នុងការបំបិទធំហ្នឹងគឺមិនឲ្យយើងធ្វើអីបន្តទៀតបានទេអញ្ចឹងណាហើយកន្លងមកពីពួកខ្ញុំយើងមានការសហការគ្នាជាមួយនឹងខាង WRC ជាមួយនឹងខាង CATU ហ្នឹងយើងបានជំរុញទៅក្រុម brand ខាង BBH ហ្នឹងគឺរហូតដល់ទទួលបានដំណោះស្រាយឲ្យពួកគាត់ហ្នឹងបានវិលចូលទៅធ្វើការងារវិញទាំងអស់គ្នាតាក់ទងនឹងថ្នាក់ដឹកនាំដែលត្រូវបានគេប្រជុំនៅខាងក្រៅហ្នឹងអញ្ចឹងណាចឹងជាសរុបមកករណីនៃក្រុមហ៊ុនស៊ុនស៊ុយស៊ីងនេះគ្រាន់តែជាឧទាហរណ៍មួយដែលខ្ញុំចង់លើកឡើងបញ្ជាក់ថានៅពេលដែលពួកគាត់ទទួលរងនឹងការប្រជុំហ្នឹងពួកគាត់អត់មានដំណោះស្រាយអត់មានអីផ្សេងហោហែតាមពិតមកដល់ពេលបច្ចុប្បន្ននេះយើងមានបញ្ហាប្រឈមជាច្រើនដែលខ្ញុំលើកឡើងថាមានករណីក្នុងការចោទប្រកាន់ពីបទប្រើប្រាស់គ្រឿងញៀនមានការចោទប្រកាន់ដោយរឿងករណីរោងចក្រ Winstar ស៊ូអីហ្នឹងពាក់ព័ន្ធជាមួយនឹងការចោទប្រកាន់គាត់ឲ្យថាគាត់នឹងលួចរបស់របរគេហើយបន្ទាប់មកចាប់គាត់ដាក់គុកអីហោហែអញ្ចឹងសរុបមកវិញថាតាក់ទងនឹងករណីនៅក្នុងការប្រជុំហ្នឹងគឺមានកើតឡើងជាច្រើនដែលយើងមកដល់ពេលនេះយើងអាចនិយាយបានថាយើងអត់ទាន់ទទួលបានដំណោះស្រាយដូចជាករណីខ្លះតាក់ទងនឹងករណីនៅក្នុងរោងចក្រ YCT អីហ្នឹងគឺពាក់ព័ន្ធជាមួយនឹងការបៀតបៀនដែលកម្មករទទួលរងការបៀតបៀនអំពីថ្នាក់គ្រប់គ្រងរបស់ខ្លួនឯងហើយមកដល់ពេលនេះគឺអត់មានដំណោះស្រាយហើយយើងក៏គ្មានជំរើសដែរអញ្ចឹងណាចឹងបើតាមអ្វីដែលជាការសន្និដ្ឋានរបស់ពួកខ្ញុំនៅក្នុងការធ្វើការងារទៅលើវិស័យហ្នឹងយើងអាចនិយាយបានថានៅក្នុងប្រទេសកម្ពុជាយើងវាមានការអនុវត្តច្បាប់ហ្នឹងគឺវានៅមានកម្រិតខ្លាំងមែនទែនអញ្ចឹងណាអញ្ចឹងយើងយល់ឃើញថាបើសិនណាយើងប្រើយន្តការក្នុងស្រុកតែមួយគត់គឺវាមិនអាចឲ្យកម្មករយោជិតរបស់យើងនោះទទួលបាននៅដំណោះស្រាយឬក៏ដោះស្រាយបញ្ហាឲ្យពួកគាត់បានទេអញ្ចឹងណាតើតែមានការជំរុញទៅតាមរយៈអង្គការដៃគូរបស់យើងនៅថ្នាក់អន្តរជាតិ អង្គការដៃគូរបស់យើងជាច្រើននៅក្នុងអន្តរជាតិហ្នឹងសហការគ្នាជាមួយនឹងខាងសហជីពនៅក្នុងស្រុកទើបអាចជំរុញឲ្យមានដំណោះស្រាយសម្រាប់បងប្អូនកម្មករនិយោជិតនៅក្នុងប្រទេសកម្ពុជាយើងអញ្ចឹងណាចឹងសរុបមកអ្វីដែលខ្ញុំបានលើកឡើងហ្នឹងគ្រាន់ខ្ញុំអាចនិយាយបានថាជាបញ្ហាដែលកើតមានជាក់ស្ដែងនៅក្នុងប្រទេសកម្ពុជាយើងហើយយើងកំពុងតែប្រឈមមុខនៅបញ្ហាជាច្រើនទៀតហើយយើងចង់ជំរុញឲ្យមានការដោះស្រាយហើយយើងនឹងបន្តនៅកំពុងតែដោះស្រាយបញ្ហាទាំងអស់ហ្នឹងអញ្ចឹងណាចឹងខ្ញុំសូមលើកឡើងប៉ុណ្ណឹងហើយបើបងប្អូនមានជាសំណួរអីអាចសួរខ្ញុំបានអញ្ចឹងណាចាអរគុណច្រើនបង
Thank you so much, Sophorn. It was so helpful to hear that case for you, and just to reiterate, I mean, in that case that was threatening the freedom of association of workers in that factory, the kind of threats that were being made were very clearly GBVH, or gender-based violence and harassment, and that again is something that is very clearly protected under Cambodian law and something that brands purport to take very seriously, and again was not picked up. So that's a really helpful example that Sophorn has shared, and as she said, is just one of the very many cases that the CATU union works on and has worked on in the past little bit. I'd now like to hand over to Aryane. We are switching to Spanish, so everyone can just stay in the same interpretation channel that they have. I don't think anyone new has joined in this last bit, so we won't go through it again. Really lovely to have Aryane joining us in the morning over there in Honduras. Aryane is a lawyer, and she has served in the role of the WRC's field representative for Central America for 13 years, which I feel like deserves a round of applause. Her work has been focused on investigating labor violations, training maquila workers on how to document and present violations according to labor laws. And she's also, of course, served as an observer in the negotiations between unions and management. And she'll be sharing the experience of how things shifted in terms of the ways in which brands respected the law in Honduras when it comes to freedom of association. So I'm going to pass over to you, Aryane. Thank you so much.
Gracias, Thulsi, y muy buenos días a todos, o buenas tardes, buenas noches a los demás. Voy a compartirles mi pantalla. Un momentito. Ok, muy buenos días. Les voy a hablar un poco sobre lo que han sido las exportaciones en Honduras. Honduras es un país muy importante para la exportación de prendas, principalmente con el destino hacia Estados Unidos. Las exportaciones en este sector han sido arriba de 3 millones de dólares estadounidenses al año. En el sector se trabaja actualmente alrededor de 91,000 trabajadores en el sector de la maquila, ¿verdad? Históricamente, la mayoría del personal en las maquilas han sido mujer, pero últimamente esto ha cambiado. Ahora un 65% de esta cantidad de trabajadores son hombres. Esto se debe a que han implementado mucho lo que son las textileras, y donde se usa más la mano de obra de hombres. En Honduras tenemos las marcas que actualmente se están produciendo. Como se puede ver, son Gildan, Sanmar, Nike, Adidas, Fanatic, Fruit of the Loom y New Agenda. Voy a comentar la siguiente, es cuáles son las violaciones que se han dado en Honduras a lo largo de muchos años. Han sido, por ejemplo, el trabajo infantil, el no pago de salario mínimo, horas extras obligatorias y no pagadas, el abuso verbal, el abuso físico, acoso sexual y otras más. Estas han sido violaciones que se han dado por mucho tiempo en Honduras. Esto marca, en Honduras hay dos momentos en que se marca un antes y un después del 2009. Y estas violaciones son las que se dan en el 2009. Debido a todas estas violaciones que ocurrían en todos los trabajadores del sector maquila deciden organizarse y deciden ejercitar su derecho a la libre asociación. Cuando esto sucede, las empresas empiezan a hacer persecución sindical, despidos, inclusión de listas negras, amenazas y comenzaron hasta a haber cierres de las maquilas, por la simple razón de que los trabajadores decidieron ejercitar su derecho a la libre asociación y sindicalizarse para defender sus derechos contra todas las violaciones que estaban siendo objeto. En Honduras tenemos muy buenas leyes que son como la Constitución, el Código de Trabajo, los tratados internacionales de los que Honduras es signataria y los mismos códigos de conducta que tienen las marcas. El problema que sucede es que aunque las leyes son muy buenas, la violación que hay siempre son fuertes. Y aunque las marcas han hecho el compromiso de cumplir estas leyes a través de sus propios códigos de conducta, siempre han ignorado y en ese momento ignoraban las leyes. No se hacían, no se cumplían. Ok, entonces, debido a todas estas violaciones y tenemos un caso insignia que es el marca el antes y el después del 2009. El mayor caso que nos denota en Honduras, que es el caso insignia, es el caso de Jerseys en Honduras. Cuando los trabajadores sindicalizados estaban organizándose, esta empresa pertenecía al corporativo Frutos de Loom de la marca Russell Brand. Esta marca en represalia porque los trabajadores se organizaron y formaron un sindicato, recibieron, y en ese momento el sindicato presentó su pliego de peticiones a la empresa y la empresa cerró. Y hasta allí nomás empezó la violación de los derechos de los trabajadores que estaban ejercitando su derecho. Ante todo lo que estaba sucediendo, el sindicato presentó ante el Ministerio de Trabajo en Honduras una queja por un cierre antisindical. El gobierno pues no llegó a ningún hallazgo respecto a la queja presentada por los trabajadores y ahí quedó, no pasó absolutamente nada. Ante la falta de acción del gobierno, los trabajadores decidieron presentar la queja ante el WRC y por nuestra parte iniciamos el proceso de investigación y determinamos que hubo violación a la legislación local e internacional, protegiendo los derechos de esta forma a lo que es a su derecho de la libre asociación. El sindicato y sus aliados en el extranjero presionaron durante más de un año. Durante más de un año por todos los hallazgos los hallazgos a las violaciones que estableció el WRC y las recomendaciones del WRC hacia Frutos de Loom, que no había cumplido. Finalmente, Fruit of the Loom se vio obligado a sentarse a negociar con el sindicato y ante lo cual se logró un acuerdo histórico en Honduras y único a nivel global que incluyó los siguientes logros. Apertura de una fábrica en el 2010, la que se llamó Jerseys Nuevo Día, el pago de los salarios dejados de percibir durante todo el tiempo que duró la investigación y la campaña, que fue aproximadamente de un año, la creación de un comité de supervisión para asegurarse el cumplimiento de este acuerdo y la no discriminación sindical en ninguna de las 6 plantas de costura y de la textilera que en ese momento existían en la empresa, donde la federación podía entrar y organizar a los trabajadores siempre y cuando fuera la voluntad de ellos y no habría ninguna represalia antisindical por estar ejercitando su derecho y hacer una declaración de libertad sindical y una capacitación sobre la misma, de que eran libres de ejercitar su derecho sin ninguna discriminación. Después de la firma de este acuerdo y la ejecución en la totalidad del mismo, los empresarios en Honduras y los representantes de las marcas que se producen empezaron a mejorar su respeto hacia los derechos inalienables de los trabajadores. Sabían que al no hacerlo, los trabajadores, con el apoyo de organizaciones como el WRC, podían denunciar a nivel internacional este incumplimiento que estaban haciendo. Este cambio permitió a los trabajadores y a sus representantes ganar respeto entre los empleadores. Podían organizarse y hacer uso de las leyes y los recursos legales que existen para hacer que estos sean ejecutados tal y como debe ser. Anteriormente nunca se miraba de que un trabajador como representante, ya sea trabajador organizado, pudiera sentarse a negociar directamente con los gerentes. Eso nunca se da, ahora sí. Eso es lo que cambió y permitió el acuerdo. Producto de todo este trabajo que hemos realizado como WRC, para estas y otras fábricas en Honduras, para que se cumpla la ley, la creación de los sindicatos en la maquila creció. En el 2009, cuando se firmó el acuerdo, solo existía un sindicato. Después de este acuerdo, se lograron la creación de 28 sindicatos. 28 sindicatos que crearon una red de sindicatos de la maquila en Honduras, mismos que lograron la firma de 22 acuerdos de contrato colectivos y que está abarcando alrededor de, protegiendo estos 22 contratos colectivos a una cantidad de aproximadamente 50,000 trabajadores en el país. Como WRC, seguimos haciendo trabajos a lo largo de todos estos años en Honduras y muchos logros que hemos obtenido a través del cumplimiento y sobre los temas planteados y quejas que han presentado los trabajadores en su momento. Muchos de ellos son y que podemos identificar como la libertad a la violación sindical, el no pago de prestaciones o indemnizaciones, auditorías en seguridad e higiene, salarios robados, discriminaciones de género, falta de acomodaciones para las mujeres embarazadas, abusos verbales, físicos, acosos sexuales, horas extras no pagadas y trabajo fuera de reloj. Estas fotografías que pueden observar aquí son algunas fotografías que hemos tomado de los casos que hemos manejado, de los que hacemos mención, y es donde ellos han logrado que se respete su derecho a través de las quejas que se han interpuesto al WRC. Gracias por su tiempo y con esta concluyo con esta diapositiva y le cedo la palabra a Thulsi.
Thank you so much, Aryane. It was so helpful to hear that really great presentation about how things changed in Honduras. And so without further ado, we are going to go to our final panelist, last but certainly not least. The very wonderful Archana is the CEO and founder of the Remedy Project. She's also a UK qualified barrister and a very well-known regional expert on human trafficking and forced labor issues, advising governments, businesses, and civil society groups across Asia on a range of these issues. So I'll pass over to Archana. Thanks so much.
Thank you so much, Thulsi, and thanks for the invitation from WRC to be a part of this fantastic discussion. So I'll be sharing with you perspectives that are from a very different angle to the former panelists. I primarily do a lot of advisory work for businesses, so I see a very different side of the problem. We advise extensively on issues around remediation, grievance mechanisms in particular, and we work a lot with brands, but also with suppliers to have the benefit of having different perspectives due to that. I guess, if I was to start somewhere, let me start with the ecosystem of remedy. The ecosystem of remedy consists of a degree of complementarity between state-based mechanisms and non-state-based mechanisms. Essential to this ecosystem are organizations like the WRC, NGOs, trade unions, etc., who really bring the complementarity together and who really are there for that accountability and the monitoring that is necessary to ensure that workers' rights are being respected and represented. We do know also that due to weak access to state-based grievance mechanisms or to some fundamental failings within state-based mechanisms that were mentioned in the presentation by Sophorn, that actually there is a very, very big reliance on grievance mechanisms run in and by non-state-based organizations, multi-stakeholder organizations, or even supply chain mechanisms. And this disproportionate reliance brings alongside with it its own issues. So we know, for example, that grievance mechanisms are often not trusted. There is a great fear of retaliation by workers. There's often a lack of clarity over what is the process, what are the outcomes, and should I be invested in this? But more importantly, grievance mechanisms very often fail to pick up some of the harder to pick up problems like gender-based violence or sexual harassment, psychological coercion, etc. We also see, for example, when it comes to issues around human rights defenders facing retaliation, it is very difficult for that to come across and to be conveyed into a brand and for a brand to be able to step in and support in any shape or fashion. This primarily happens because all brands have a code of conduct which states very clearly that there is a zero tolerance to retaliation. However, how do you translate that into practice? And how do you ensure that this zero tolerance is indeed zero tolerance and that there is protection provided at the ground level when it is required in two ways, whether this is, interventions at the supplier level or interventions through a third party that can provide that protection. Now, there are two problems with what I'm suggesting here. One is it assumes that the brand actually knows, has good visibility, and understands what is happening at supplier level. However, colleagues who have gone before me have just expressed how there are very clear difficulties around the brands themselves having very clear visibility due to reliance on social audits and various others of what is actually happening on the ground, even if it is issues like a supplier not complying with a local court order. The second issue with this is that, we observe daily in the work that we do, the big gap between international standards, which are embodied in the code of conduct of the various suppliers, of various brands, and then the local standards, which are the local standards to which suppliers are operating. And within this, there is a complete confusion and paucity of, information around what is happening at the ground level, what is being observed and what isn't being observed. One of the biggest problems in the way that brands do their due diligence currently is that it is very top-down. You don't really get to hear from workers what does risk look like from their perspective. What do they find threatening in the workplace? What is unsafe for them in the workplace? And as a result of this disconnect between the top-down and the bottom-up approach of looking at risk, there is a lot lost in that picture. That translates into very poor due diligence visibility, but also translates into consequentially poor remediation of these issues. Now, I've had the experience of being instructed by a brand that had been the recipient of a WRC report to actually go into the factory in question and validate the findings that were made by WRC and to look into if the findings were validated, what would remedy look like. And very interestingly, the findings of WRC all made sense. They were stacked up and our findings corresponded with theirs. And when it came to remediation, what was really interesting was the remediation was very clearly articulated in line with the local labor laws. Now, there could be an argument that actually, if these had been articulated under international standards, would the workers have got more or would they have stood to benefit more? The fact of the matter is that these violations took place at a local supplier. The supplier was purporting to follow local law and nothing else. The brand does make the supplier sign its code of conduct, which says that it's abiding by international standards. But the visibility on the ground should have made it very clear to the brand that there was very basic, if any, compliance with local laws. And that's a problem first and foremost, even before international standards come into play. So it was right to peg the request for remediation at that level and to push for it. In very exceptional cases, will you see those cases, make it to a court of law at a high level and really get into the weeds of getting compensation, which truly reflects, interest payment, loss income, damage caused to the individual, etc. But that truly is exceptional. So the other observation I would like to make is when we look at the way problems are attributed across the value chain, the value chains are currently structured in such a way that human rights due diligence done by brands identifies problems, for example, forced labor at a supplier level. It is always the supplier's fault or the supplier's problem rather than being a business model related issue. As a result, the attribution of responsibility falls on the supplier, and the responsibility for remediation also falls on the supplier. So if you look at a case of recruitment fees, for example, we see very often in practice that the brand will lean on the supplier to repay recruitment fees paid by migrant workers. This will potentially remain open for a period of a year, 2 years, while the supplier says they just don't have enough working capital to make those refunds. The brand will tend to act expediently to step in and to support if there is an organization like the WRC that has its eyes on them, or if there is a WRC report that is going around and the brand feels pressured. It is very common for brands to have a heightened response to situations where there are reports of this nature, and they're generally escalated and dealt with very promptly. Is this sustainable? Is this the right way to look at it? I mean, these are issues that are business model related. It is absolutely vital for remediation to take place. The correct degree of responsibility needs to be attributed. While we fixate on looking for indicators of forced labor, we miss the fact that there are no decent work indicators present, and therefore the environment can only be exploitative. Whether you're looking at the absence of freedom of association, whether you're looking at passport retention, or whether you're looking at poor living and working conditions. And therefore, it becomes really important to be a little bit smarter about the way we look at this. And if it is a business model related issue, that there is the right degree of responsibility that is taken by the supplier for remediation and by the brand for the way it does business and for the way it purchases and prices products. And without this, we don't stand to find any kind of equity in the value chain or any kind of, way forward that really will bring some semblance of remediation that is prompt, that is appropriate, and that is fair and effective for workers. And just to end with, what does it mean? What do the new HRDD regulations mean? They provide a formalized framework of transparency and accountability. They provide a constructive space within which, CSOs, trade unions, organizations like the WRC have the space to engage constructively. The ability to say there is no visibility, we don't know, we can't see, is diminishing with the advent of these laws. And these laws are an opportunity not to maximize on compliance or to dump compliance on suppliers, but rather to look at, how can this really be used to address the root causes of these issues? But more importantly, how can this be used to improve stakeholder engagement and workers' participatory rights in moving their own cause forward? So I'll leave it there for now. Thank you.
Thank you so much, Archana. As ever, a huge amount of stuff there that's thought-provoking. I feel like I could ask some follow-up questions, but maybe that's a good thing because we are now going to be moving into questions for the panelists from the audience. So again, if you would like to ask any of the panelists or all of the panelists a question, please use the Q&A function at the bottom of your screen. it would be helpful if you could specify who you're directing your question to when you ask it. And if you're asking just for follow-up information on any of these cases or on any of the interventions that have been made or what Archana shared, please make that clear and we can send that via links in the chat. As we're waiting for questions to come in, I might jump in with a couple I have myself. I'm going to go first to Sophorn. You mentioned, Sophorn, in your intervention, how this kind of diminished civic space impacts on the independence of institutions that are supposed to uphold Cambodian law, like the Arbitration Council. I wonder if you can say a little bit more about an example where a brand has undermined the law in Cambodia by ignoring this context in a way that's had an impact on worker rights.
Chaខ្ញុំតន់សំណួរអរគុណចាអរគុណ Thulsi សម្រាប់ការសម្រាប់សំណួរដ៏មានសារៈសំខាន់ខ្ញុំគិតថាជុំវិញនៅក្នុងការចូលរួមរបស់ brand ប្រកបណាស់វាចូលរួមចំណែកនៅក្នុងការធ្វើឲ្យយន្តការនៅក្នុងស្រុកហ្នឹងវាអត់មានដំណោះស្រាយណាបើសិនណាមានការចូលរួមជំរុញពីអង្គការដៃគូចូលរួមពី brand យ៉ាងសកម្មពីអង្គការដៃគូយើងសកម្មហើយនឹង brand ខ្ញុំគិតថាប្រកបណាស់វានឹងជួយឲ្យមានដំណោះស្រាយសម្រាប់កម្មករយោជិកនៅក្នុងប្រទេសកម្ពុជាយើងអញ្ចឹងណាហើយបើសិនណាខ្ញុំគិតថាបើយើងបដ ாய் ឲ្យប្រើប្រាស់នៅក្នុងយន្តការនៅក្នុងស្រុកខ្ញុំគិតថាវាប្រកបណាស់វាអត់មានដំណោះស្រាយទេហើយប្រយោជន៍គឺបានទៅក្រុមហ៊ុននិងបានទៅក្រុមអ្នករកស៊ីដែលអ្នកមានលុយមានអំណាចពីព្រោះកម្មករគឺជាភាគីមួយដែលយើងអត់មានលុយហើយយើងអត់ហើយបន្ទាប់មកគេប្រើប្រាស់សិទ្ធិនៅក្នុងការគៀបសង្កត់ទៅដល់សិទ្ធិរបស់យើងអញ្ចឹងណាចង់មិនចង់គឺកម្មករក៏អត់មានជំរឿសហើយនៅពេលដែលគេរុញឲ្យយើងទៅប្រើយន្តការគឺប្រើយន្តការដែលអត់មានប្រសិទ្ធភាពហើយអត់មានដំណោះស្រាយខ្ញុំឧទាហរណ៍ថាគេប្រើជំរុញឲ្យយើងទៅប្រើយន្តការរបស់តុលាការប្តឹងទៅតុលាការជាដើមប្តឹងទៅតុលាការគឺយើងប្រើពេលយូរយ៉ាងណាហើយបន្ទាប់មកតុលាការនៅក្នុងស្រុកខ្មែរយើងគឺគាត់អត់មានធ្វើការទៅតាមវិជ្ជាជីវៈរបស់គាត់ទេគឺគេធ្វើការងារសម្រាប់ទៅតាមអ្នកមានលុយតាមអ្នកធំហើយបើយើងអ្នកក្រអ្នកអត់អ្នកតូចទាបប្រកាសណាយើងអត់បានទទួលបានយុត្តិធម៌ទេអញ្ចឹងណាចឹងសរុបមកវិញខ្ញុំគិតថាមានតែការប្រើប្រាស់នៅយន្តការតាមរយៈអង្គការដៃគូរបស់យើងជំរុញទៅក្រុមbrand ទាំងអស់ហ្នឹងទេដែលធ្វើដែលទើបខ្ញុំគិតថាងាកឲ្យពួក brand ទាំងអស់ហ្នឹងគឺអាចថាដោះស្រាយបញ្ហាឲ្យកម្មករយោជិកបានអញ្ចឹងណា
Thanks so much for that, Sophorn. I'm going to now ask a follow-up question to Pratibha. It says, you mentioned earlier how the brands simply don't follow the rule of law, and I think you gave lots of really great examples of that, including the VDA case that you focused on, but particularly on issues of gender-based violence and harassment that I know GATWU has worked quite a bit on. Brands outwardly say quite a lot about stamping this issue out and working to identify it in their supply chains. Could you share more on what your experience has been in an Indian context?
Yeah. As I told you that in garment sector in India, the rampant issues are low wages and gender-based violence. Because 85% of the women in a production line and all the males are in their supervisors section. So a patriarchy society in India, the male have more what do you call so I wanted to say that the in factory in garment sector, we can see it is a mirror of patriarchy society. So they have, the males are in power and they have the double power there. One male, as a male, they will got the power, and as a supervisor, as a manager, they will get a power, and they can easily violence, they show violence on their subordinates, that women workers. So in our Indian law in 2013, Sexual Harassment Prevention Act has came. Previously, it was only with guidelines the Supreme Court has given in a case of Bhavari Devi. So it was a guideline that Supreme Court has said that the safety of women worker at a workplace is responsibility of their employer. Whether it is government, it will apply for all the employers, all the sectors. So it has came as act in 2013, that Prevention Act, Sexual Harassment Prevention Act in 2013, which says that which mandates that in every workplace there has to be internal complaints committee, which solve the problems and even aware the workforce about this sexual harassment. Because India, like the patriarchal society like India, women will get it as normal. It is not normalized in Indian women context up to at least up to 2013 when it comes. But still, I am saying that as a union, we are struggling to give awareness about this, what is sexual harassment, so or gender-based violence. It is very normalized in thing. But when this law came, it mandates that for the internal complaints committee, every workplace has to should have the internal complaints committee. GATWU receives 3-4 cases. I will share 3-4 cases. We are getting cases with gender-based violence, but workers in one factory in Maddur, that is 80 kilometers from Bangalore, that is Shahi Exports. One woman filed a case in complaints committee, to the chairperson of complaints committee. It was unaddressed for 5 months. They have not at all addressed this her complaint. So she has targeted. She has not given work within that 5 months. This 5-month period. And again, she complained to us. We wrote letter to management, and management has constituted 58 members committee. 58 members committee. It was not, the law says only 5 to 10 committee members. And this management has constituted 58 members committee, and all the committee members have gave negative report about her only, and came up with the this one as this women is not good, and she has to apologize that woman, that man, that manager. So then I will tell you that woman is very strong, and she is a very prominent union leader in that unit. So workers are not come up with these issues. When she came up with this and she got like this, all the worker has they're scared. So this women only got like this. What about us? Is if we took the cases like this, what will happen to us like that? This is one case. And like this, brands also knows about this. They are not addressing this, or they will only do it. Oh, whether you have the Internet Complaints Committee, okay, tick. Whether it is working or it is giving awareness to workers, nothing will brands will ensure. So only for namesake, it is the ICC should be there like that. And from government also, there is no implementation or there is no any implementation facility or something like that. So it's just like on papers, that's all. It's not at all working. And brands also, it's not they are not looking on this. They want only their production, only their quality, and only their profit. That's all. Whatever is happening here, they just ignore this, and they just don't want to listen to it also. And patriarchy society like India, it is very, very difficult to get this type of cases, because society thinks that it is, as you all know, it is a mistake of women only. If anything happens to women, it is because of her only, her own dresses, her own behavior, like that. So in the factory also, it will treat like that only. Even all the suppliers will stand behind their managers, not on their women employers. They will stand behind on this one, and they will support them also. So I'm telling that all the systems is all the system, that is whether capital, whether management, whether brands, or whether our suppliers, all are patriarchy mindset, and women are continuously facing this gender-based violence. This is rampant in all in Karnataka garment industry. The gender-based violence, also workplace harassment. I'm not only saying that sexual harassment, it is workplace harassment also, humiliation, and hire and fire, and yeah, everything related to production, everything related to women, everything. So denial of week, the weekly off, denial of their leaves, everything is like this only. So
Thanks so
this
much,
was
Pratibha. It's really helpful to have that example, particularly of the Internal Complaints Committee. This is, of course, something that's enshrined by Indian law, and we're simply not seeing brands taking seriously their responsibility to ensure that the spirit of that law is embodied by ensuring that GPVH is prioritized and that there is a genuine space for women workers to be able to raise these complaints. Thanks so much. I can see now we have 2 questions directed at Archana. I'm going to go ahead and read out the first one for you, Archana, which is, how do you think CSDDD could impact the purchasing practices of brands?
The $1 million question. Oh, well, the letter of the law, the dream of the CSDDD is, to really see equity across value chains. And for that to happen, there are a lot of prescriptions in CSDDD around building up suppliers with capacity building, financial support for SMEs, and also revision of purchase price and purchasing practices where that would help to bring a degree of equity across the value chain. In practice, what I have seen that translate into so far has been suppliers getting very curious about how they could rally behind this content and really come back to the negotiating table with purchasers. Looking at industry associations as a collaborative framework to bring suppliers together so that they can come to a common position and think about strategies and ways in which they can engage with brands to move the needle on the purchasing price. In my practice, what I'm seeing primarily is that there are a lot of requirements and requests going from brands to suppliers primarily from a compliance perspective. Do this, do that, improve your standards. We want you to report more. We want data on this and data on that, contractual assurances and the works. We are also seeing brands put in place and invest in a lot of supplier capacity building, particularly around handling grievances, risk identification, etc., and also supply chain mapping. However, one thing that remains very elusive and very unpopular remains the conversation about the purchase price. So in cases where we've had complex remediation issues that have tied down to business model problems, we have gone back to brands and said, well, why don't you consider raising the unit price? And the uplift of the unit price could go back to the workers in order to refund, let's say, recruitment fees or provide for remediation that is due. And there's been a flat out refusal. So far, there is still a separation of this is business, these are our KPIs, the profits are our bottom line, and the human rights consideration are something separate. That's something the sustainability team deals with. It's very, very common to see two big silos and they haven't come together yet. So this dream of, revisiting purchasing practices, etc., can only happen if business truly accepts that the real risk to business is the risk to people and planet. And we're really far from that.
Thanks so much. There's actually another question that's been directed to you, which I'm going to read from the chat. This says, thank you, Archana, for sharing your insight. I hear one of the structural challenges brands face is the over-reliance on third-party audits that often overlook violations, and a natural solution to this challenge is to have brands sign a collective agreement with unions and protect unions organizing, enabling brands to have a direct line to unions in factories. So in the work that you've done and your experiences with brands, what do you think prevents brands from adopting this as a solution?
Yeah, it's really interesting because in most brands, salient human rights risk issues, you will see freedom of association appear. It is largely put down on the conditions prevailing in producing countries for these restrictions on freedom of association. And even where these exist, where there are such restrictions at local law level, there is not much attempt made to look at what could be done to work around some of those, to give workers more participatory rights, and actually to hear workers' voices better and more. One of the blessings and curses of the last decade has been the worker voice tools, I do feel, because this has become a way to tick a box, a way to ask yes and no answers, questions, and to basically say we've done our worker engagement. However, that does not replace human engagement. It doesn't replace the engagement that you would need to have with unions, etc. I haven't seen in the work that I have done that there has been much progressive action taken by brands in relation to look at what are the different ways in which freedom of association can be respected, cemented, even where there are local headwinds to this effect. And in fact, there is a reluctance to engage with unions, and there is a reluctance to delve into sort of direct engagement as well. So I can see that there would be potentially some reluctance around even engaging with NGOs, particularly where there isn't trust built. But again, I think, with hopefully human rights due diligence frameworks that really look into this idea of collaborative framework, collaborative working, meaningful stakeholder engagement, that there might be opportunities to have a framework within which that trust is built so that this kind of rapport can take place going forward.
We have 4 minutes left, and one more question has come through anonymously. Again, for you, Archana, sorry to be throwing these all at you. I'm also aware that you heroically are doing this very late in your evening, nearly the 3 a.m. that it is for me, but not quite. And this last question reads, what do you think about the use of local labor laws? Do you think that this changes how brands conduct due diligence? I think this is in reference to if we're pushing for remedy, does this then mean that brands are changing how they identify risk?
Listen, I think there has to be a degree of honesty about what is actually happening. Can we stop pretending for a moment that we are abiding by international standards in local producing countries? Let's drop that first of all. And if we are accepting of the fact that, you know, suppliers have to follow local laws, local labor laws, etc., it's it's on both sides. The states in producing countries also have a responsibility to make the law accessible, where it is not possible for a single case of an individual to be brought before conciliation or arbitration because it has to be in numbers. That's hugely prejudicial to individual grievance who may want to bring a case forward. So there is a case that local labor laws are there in their numbers. However, the enforcement of local labor laws is very poor. The institutions that serve them in many countries, those decisions of the conciliation tribunals or committees are non-binding. So that, you know, eventually you're left to go fight with your employer over whether they're going to accept it or not, and whether you're going to get remedy or not. So that there is a clear case that if we are able to do satisfactory due diligence on the ground to at least ensure that local labor laws are being followed and are being upheld, in the case that they're not being upheld, that there is visibility around the fact that the grievance need to have access to remedy, whether that's through state-based or non-state-based mechanisms. If those remedies are not available domestically, then there needs to be an upward face, an escalation within the ecosystem of remedy, so that that can be brought either at brand level or at a supply chain mechanism level. But again, that socialization, that awareness, the pathways, and the ability to access those are absolutely critical. And very often it's down to the support of an NGO or down to the support of a trade union that makes all of this possible. So they remain critical components of the ecosystem, and as critical enablers, they also have to be supported in these endeavors.
Thank you so much for that intervention and for the flurry of questions that came your way. I think we are at time, so I would just like to say a huge thank you to our 4 panelists for very generously giving their time. For those who are in the Asia region, it is very late. I hope I have made some sense to all of you there. I am currently in Australia where it is 3 a.m. So I've been battling through, but it has been lovely to see the numbers of participants that have been here. This session has been recorded. It will be made available to watch and to share via the OECD website. You should also have the contact details for the WRC in case you have any follow-up questions for us or any of the panelists. And we'll also be able to send you a follow-up email to all of those who registered with some follow-up references for the cases that were discussed today. Thank you so much, everyone. Bye.
Thank you.
Thank you.